afternoon, everybody, and welcome to True Vision Christian Community. Sorry, Josh made a joke before we came on camera. Anyway, welcome to True Vision Christian Community, and for our Wednesday Lunch and Learn. Today, we are learning about how to navigate many housing issues that I know many of you are facing, both here in Lancaster and all over the state. And so we want to take some time to talk about those issues. I have two special guests with me. I'm glad to call them friends and co-workers in the struggle. We have to my left, your right, Leisha Farias, who is a part of the think tanks on poverty. She's our fearless leader for the Lancaster think tank. And next to her is Josh Goodwin. For those of you who've been to some of the stuff that we've done, you've seen Josh. If you've stopped by on Tuesdays from 9 to 11:30. You've seen Josh here. He's the managing attorney for Southeastern Ohio Legal Services. So here's how this is going to work. You're not going to see me. You'll hear my voice pop up when necessary, but you're not going to see me because I get to be tech guy. So listen, if you're watching, if you have questions as we're going through our presentations or anything that you like to have something that's like, you're like, hey, I need to ask this question. I need to know how to deal with the situation. You can comment on this video. I'll be in the sound booth going through it, watching our streams. And when there's a question, I'll let them know, hey, we have a question from the audience. Also, if you're in the area right now and you're like, hey, can I come and watch? Come on and watch. We're here, 706 West Willing Street. The door's wide open. Come on in. We got pizza. We got salad. We have various types of caffeinated beverages for your eating pleasure. It's totally, completely free. Come by and join us. So as I mosey my way back to the sound room and get ready to be tech guy, go ahead and share with our audience what you do.
Thank you, Kaz. It's wonderful to be here with you today in your church in this great setting and great location. My name is Leisha Farias, and I'm a lead organizer with the Think Tanks on Poverty. And the think tank started in 2014 in Newark, and now we have think tanks in Perry County, in Zanesville, and Newark, and now we have one bubbling up here in Lancaster and one in Mount Vernon. So the idea behind the think tank is that we know that there are lots of things that are going on in our communities, and there are systems and laws and policies in place and things that keep people in poverty. So our idea is to listen to people that are experiencing those issues, find out what's really keeping people down, and then bringing people together to use their voice to make change. So we are really building a movement of working and poor people who are fighting for justice, and we really invite you through Josh and through Kaz to really get involved to lift off this Lancaster think tank on poverty. So it's a real pleasure being here. Thank you, Kaz.
Yeah, thanks, Cass. As Cass mentioned, my name is Joshua Goodwin. I'm the managing attorney of the Chillicothe Office of Southeastern Ohio Legal Services. For those who aren't familiar with what we do, we provide free legal advice and representation to folks experiencing poverty as well as the elderly in 7 counties, but right here in Fairfield County, Lancaster as well. I'm from Lancaster. This is my hometown. This is where I live. And as Cass mentioned at the top, we're here every Tuesday from 9:30 to 11:30 to meet with folks in the community about any problems they'd like to discuss with us. So I've been an attorney since 2006. And I do all sorts of civil things, so housing, we're talking about here today, but also just about anything that affects folks in poverty, from consumer issues, divorces, domestic relations, custody, a lot of public benefits issues, Medicaid. I think healthcare is incredibly important, access to healthcare. So I kind of run the gamut. I'm a generalist in that regard. And I'm incredibly excited to be sitting here with Leisha to talk about housing in particular today.
All right, wonderful. Again, Pastor Cass here, disembodied voice. All right, once again, if you're watching, feel free to share this. Share this on Facebook. We're also on Twitter as well. Go ahead and retweet this, share the YouTube link. I know a lot of people have a lot of questions. So we're going to go ahead and we're going to move into the PowerPoint that Josh has prepared for us. Now, here's the cool thing about the PowerPoint and technology. You'll be able to see it. Yay. So, let's go ahead. Josh, whenever you're ready.
Sure. So I wanted to just kind of give folks an overview about housing issues that they're likely to face and need to think about as they're going through renting a place here in Ohio. And so I want to talk about how leases work in general. Something I think is completely underlooked or not given enough attention, which is how to work with your landlord, how you get repairs made, and how the eviction process works. I like to be as interactive with these things as possible, so I would encourage folks to ask questions in the comments as we go along as I'm hitting things. I'm sure Cass will signal me to slow down and answer questions as we go. I think I already kind of talked a little bit about who I am. But one of the things I didn't mention is that we're at eviction court here in Lancaster every Tuesday. If not myself, then some of my colleagues. It is much easier if folks call us in advance. Give our office a call. Let us know that you're facing eviction. I'll talk about that later on. But we are here at the courts. So let's start by talking a little bit about leases. A lease at the end of the day is just simply an agreement between you and the person that owns the home that you're going to live there, be it a mobile home, be it an apartment complex, or just a single family dwelling. We usually see two different types of leases. One's oral, that's just a handshake agreement between you and the landlord that, hey, I'm going to live here, I'm going to live here for a while, and I'm just going to pay you this amount of money in rent. Nothing's ever written down, things just work themselves out. The other type of lease we'll see is just a written out agreement, and that can be, I've seen written out agreements that are about 4 or 5 sentences long, and I've seen ones that are 12, 13 pages long. There are pros and cons to both sides. So with an oral lease, I think a lot of people want to just assume that it's not valid, that it's not enforceable. But the reality is that's just as good as a written lease in terms of being enforceable. It can be for any length, up to a year. So you might just be on a month-to-month lease, or you can agree with your landlord that you're going to rent a place for a year. It starts getting a little tricky with oral leases that for longer than a year, and those really need to be in writing. But you could do a 1-year lease and just have it all be on a handshake agreement. And there are just some really basic terms to an oral lease. So you might think that, the only thing that matters is the amount of rent that I'm going to pay and how long. The Ohio Revised Code actually sets forth that if you have an oral agreement, there are a whole bunch of things that you are responsible for and your landlord's responsible for. So just because it's an oral lease doesn't mean that your landlord doesn't have to fix things or anything along those lines. Now with every pro, there's always a con. Oral leases can be harder to prove. If you have an agreement that, hey, instead of paying rent, I'm going to work for somebody, we see that commonly, and those can be a challenge to prove in court because we don't have it reduced to writing, and then it becomes a question of credibility and who's the judge going to believe, the landlord or you. They also do provide a little bit less certainty. Most of the oral leases that we see end up being month-to-month leases, and that's fine in certain circumstances. For some folks, they want that freedom to leave at any point. But if you're hoping to stay in a place for a long period of time, that oral lease and that lack of certainty can just kind of serve as a cloud. And it also puts the landlord in a little bit more of a strength of power because they can be like, hey, if you don't do what I say, I'm just going to stop leasing to you next month. There are certainly some pros to having a written lease. They are easier to enforce because when people bring me their written lease, I can be like, hey, right here it says you're going to do X, Y, or Z. Lawyers like having things in writing. Judges like having things in writing. That's the world we like to work in. So having everything written out in a lease is a lot easier in some ways. And that's where the more certainty comes from. It also makes clear your rights and obligations a little bit more. So I mentioned that Ohio law sets out what everybody's rights and obligations are as far as landlords and tenants. But sometimes, you might want to agree that your landlord is going to do extra things. So for example, it might say who's going to pay the utilities, who's going to take care of mowing the grass. All of those things can be added in a lease, a written lease, and it becomes a little bit clearer. And people can point to it and say, hey, you're not living up to your end of the bargain, be it the landlord or the tenant. Some of the downsides to having a written lease, there's more penalties for breaking early. So if you've got a 1-year written lease and you leave after 2 months, you're technically on the hook for the remainder of that lease. And that can be costly. There's some ways to get around that at times, but it's you're kind of locked in if you're going to do a 1-year written lease. You can also have late fees. It's really hard to do late fees in an oral lease, but I see it pretty common in written leases. The other thing is sometimes we'll see landlords insert things in their lease that they're not legally allowed to enforce in the hopes that you're going to follow through on them. So for example, attorney's fees are one that I see a lot of times in leases, saying that if you the tenant, do something that causes them to take you to court, that you're stuck paying their attorney's fees. That's not really enforceable, but doesn't mean landlords don't try to insert those in there. The key with any lease, whether it's written or oral, is that you understand what the terms are and that you understand, have an agreement with the landlord that you're all on the same page. So I'll take a break there to look back at Cass, the voice, to see if there's any questions that folks had about leases in general. As he's shaking his head no, I'll move on. I mentioned at the top that I think we lawyers spend entirely too little time talking with tenants about how to work with their landlord. Oftentimes, by the time we get involved, either we're looking at a lease at the beginning and being like, yeah, you should know this about your lease, or somebody's calling us when things have gone catastrophically wrong. Nobody ever comes into my office and says, hey, Josh, I just wanted to let you know that everything's going great with my landlord. Have a good day. That's never when people come to me. When they come to me, things are off the rails typically. And usually you can point to a couple of things, and there's always a point where, it seems like there's always a point where, had there just been some communication between you and your landlord, that things could have been fixed. The idea of talking to your landlord seems foreign to some folks for some reason, in a way that I don't fully understand. If you talk with your landlord on a regular basis, even if it's just saying, hi, how you doing? Those niceties, that building up of goodwill makes it a lot easier for when things aren't working with your landlord, for you to approach your landlord and like, look, you got to fix this. It's a lot harder for your landlord to stab you in the back if you have a decent relationship. So spend time getting to know your landlord and talking with them. Let them know when things aren't working well. Let them know in advance if, hey, I'm starting to hear a creak at the door. So that you're calling them and letting them know before it becomes a really big problem. And I am going to take a moment to get on my soapbox about this communication thing. In general, I think we do not communicate with each other enough. We try to do everything by text. We think that we always need to have a written record of things. When you start putting things in writing, sometimes people get upset. Sometimes people get paranoid. Oh, well, this must mean that they're trying to set me up for failure or something like that. Spend time actually communicating face-to-face, calling people. I think that it would make life a lot easier because so much nuance gets lost by text.
Can you give an example of how that can get misconstrued? Like if you're using text rather than talking face-to-face or speaking on the phone?
Yeah, I see it actually happen most often in custody cases, to be honest, where one parent is just, sending things by text. they make either what they think is a funny joke, or they try to be ironic, and that never comes across well in the written form. In the landlord-tenant context, the moment when things are written down, I've seen landlords be like, well, they just keep texting me all the time. And there might be a generational aspect to this, where I've had older landlords that just don't text normally, and their younger tenants are texting them all the time, and I don't mean to be ageist about that, but that's when I see those kind of problems arise. And again, yeah, just talking past each other, and it's harder to sort through that by text than it is in person, or just talking on the phone. The other thing that I think is important when you're working with your landlord is not all landlords want to give receipts. So much of my life would be easier if people would get receipts. Now, that might mean that you need to take a receipt with you. That's fine. When you go pay your rent, bring a receipt with you that all your landlord has to do is sign. Make it as easy as possible for your landlord if they don't like to give receipts. I've had a number of landlords that would have said, yeah, I would sign a receipt if they would just bring me something. I just don't feel like having a receipt book myself. That doesn't seem like a great way to run a business from my perspective, but I get it. And at the end of the day, again, if you're being evicted for non-payment of rent and you think you paid your rent, it becomes a question of credibility, and it makes your attorney's job a whole lot easier if you can bring in the receipts showing where you had paid it. So what are not receipts? A statement from your bank showing that money was taken out of an ATM because you always paid in cash. That's helpful. It's an indicia or indicator that you made a payment, but it's not a receipt. It doesn't show that the money was received. Same way with the little strips you get from a money order. Unless you can prove that was cashed, that's not actually a receipt. It's much better, even if it's just written on a napkin, anything in writing showing that your landlord got the money is better.
I rented a farmhouse when I was raising my daughters, and it was through a family. Oh, I'm sorry. It was through a family relationship that we were able to rent this house, and it was an oral lease, and it was kind of a difficult situation. I was a single parent at the time, and I remember, I was just very fixated on making sure that we paid when I got paid, that we would pay the rent, and we would walk across the yard to their business, and I would hand them a check, and I never got a receipt. Which I should have, but I can remember there was one time where it was days and days after the due date of the rent, and landlord called me up and said, "Leisha, you didn't pay your rent." And I'm like, "Oh, I'm sure I did. I never miss." And I hadn't. But if I hadn't had the good relationship, with him or with them, I don't know what would have happened. But yeah, I had forgotten. It just skipped my mind. Things get busy, people get busy. But if I'd had that practice of getting a receipt, I would have been in much better shape.
Cass.
Okay, this is the digital question, I just thought about this. Would it be wise to keep pictures of our receipts as we get them so we don't lose them?
Yeah, whatever's easiest for you. Some folks like keeping the physical receipts. I was a terrible tenant when I was a tenant because I would lose those physical receipts left and right. I mean, I always paid by check, so I had that kind of backup, I guess. But yeah, I would have lost them. So if you can take pictures, that's fine. Those are usable in court for the most part. And it's certainly better than nothing. So yeah, take pictures if that's what's easiest for you. And thanks for sharing that story, Leisha. A lot of landlords really they want to work with folks. At the end of the day, they just want their money. And so, again, if you've been working with them all along, you've been talking with them, they're much more likely to work with you to get things caught up. So let's talk a little bit about what happens when your landlord's not making the repairs This is something that we see on a pretty regular basis in my office, where you've entered into a lease, you're making your payments like you're supposed to, but your landlord is just not fixing things when you ask them to. I want to make one thing, and if you take nothing else from this part of the conversation, remember this. The most important thing you should do is continue to pay your rent. If you do not pay your rent, you will get evicted, and there might not be anything I can do to stop it, because your landlord is going to evict you for not paying your rent, and there's really not a whole lot of great defenses to that at that point in time. So if something's not being fixed, continue to pay your rent until you've gone through the steps necessary to resolve that problem. So let's talk about what you can do to actually get the repairs made. I don't know if you can go forward a couple slides. There are 4 real options in Ohio to go about getting your repairs made. 1, you can escrow your rent with the court. 2, you can break your lease and leave. 3, you can get a restraining order from the court ordering your landlord to make the repairs. And 4, most drastically, is you could ask the court to have the property sold and given to somebody else who will take care of the property properly. So I want to talk a little bit about escrowing your rent with the court. And we'll come back to the process of doing this and breaking a lease in a moment. When you escrow your rent with the court, what you're doing is, instead of paying your rent to your landlord, you're paying your rent to the court. The idea behind it is your landlord's going to be like, hey, I'm not getting my rent money. And the court's going to be like, yeah, that's right. Get those things fixed and we'll give it to you. So it's to provide both a carrot and a stick sort of to the landlord to make those repairs that they need to make. The upside to escrowing your rent with the court is it reduces your chances of being evicted, because as long as you're making your payments timely to the court, your landlord cannot evict you for not paying your rent, even though they're not getting it. And like I said, it provides an incentive to your landlord to get those repairs made, and you get to maintain your current housing.
Josh, so what is the process? So if I'm living someplace and I've asked my landlord to fix things and they're not, how would I do that to escrow my rent?
Yeah, so there's a process to it. First, you have to be current in your rent when you start the process. If you're 3 months behind in your rent, you cannot escrow your rent with the court. What you're going to need to do is give your landlord notice in writing of what repairs need to be made. Telling your landlord is not good enough. You have to do this one in writing. And we take writing to be pretty broad. You don't necessarily have to type it up in a letter and send it to them. We've been taking the position that a text message is writing, that an email is writing, as long as you can show that it got sent to the right place. You have to then give your landlord a reasonable period of time within which to get things repaired. We typically say that's 30 days for most things. So if you've got a broken window or something like that, you really need to give your landlord 30 days. And that's not 30 days from when you send the letter necessarily, but it's 30 days from your rental period. So for example, let's say you owe rent on the 1st of the month. If the window is broken on the 15th of the month, well, you're really going to end up giving your landlord 45 days before you can escrow your rent with the court, because you're going to send the letter on the 16th that says, hey, this is broken. I need you to repair this. You still have to pay your rent on the 1st of the month when it comes around, and you can't really begin that escrow process then until that next month. So that 30 days ends up being sort of a minimum. Now, some things it's not reasonable to wait 30 days. So for example, it's the middle of winter and the furnace goes out. If you decide that you want to escrow your rent with the court, you might be able to get away with less time, maybe a week or something, if you're going to try to escrow your rent with the court. That's one of those things I think that you really want to start talking to an attorney about before you if that's the kind of repairs you need made.
So that would be something that a person could talk to a legal aid attorney, and then is there paperwork to apply to escrow your rent?
Yeah, so yes, we can talk with folks, especially if it's an emergency like that. I've got what we have on our website here, but if you go to www.seols.org and the Get Help tab, there's a lot of housing resources on there, including information on what should I do if my landlord won't repair things. And we have a sample letter that you can send to your landlord along with the instructions on how to do that. And then if after that period of time your landlord hasn't made those repairs, then you just need to go to the municipal court, take your rent with you, and tell the clerk there that you want to escrow your rent with the court. And then they will start that process for you. We typically don't get involved in escrow cases just from a resource standpoint. We do in some of the other repair issues. But if folks have questions, come see me on a Tuesday from 9:30 to 11:30 here at the church, and we can talk about it.
And do people do it? I mean, it's still very much a little known process? Are people aware about escrow?
Yeah, people are aware of escrowing their rent with the court. And I kind of want to talk about some of the cons to it because I think it will help. We have seen folks escrow their rent with the court, and one of the downsides is now all their money's tied up in the court. And so if it looks like the landlord's not ever going to make the repairs because they just don't care, you don't have that money to move on. It can also become a challenge if you're if you have a housing voucher, because if you're paying $0 in rent each month, it's really hard to escrow that with the court. Or if you're paying $20, you can escrow your $20 with the court in theory, but is that going to give the landlord really any incentive to actually get things resolved? And the process can be slow. I've seen these things drag out over a year where you just keep paying your money into the court and the landlord's arguing with the court. It's just not, court's not known for its quickness. It's just not the way the legal system moves. So it can be a really slow process. And the results can be very inconsistent. You might still be upset that there's a crack somewhere and the court's like, I just don't care about this anymore. So escrow it's got its pros and cons. I like escrow if you're early into a 1-year lease for a place that you really like. I think escrow can make more sense. If you're on a month-to-month lease, I see too often the landlord is like, well, you know what, I'm just done being a landlord. And yeah, they're not supposed to do that, but it becomes really tricky. And now you might need to move and your money's in the court. So another option then is to simply break your lease. Let's say you're on that 1-year lease and the landlord's like, you know what, I'm never going to fix this. And you're like, yeah, you're probably not. I'd be better off. I don't want to live here for another year like this anyway. If you give your landlord that letter saying, get these fixed within 30 days, after that period of time, you can break your lease and leave. You don't need to file anything in court. You just need to up and leave.
And that's if they're not doing the repairs, then that's admissible in court. Then
yeah. So obviously, if you send them a letter and they make the repairs, you can't just break your lease at that point in time. But that's kind of the goal, right? Is you sent them this letter, hopefully in good faith, that you want to stay. You just need these repairs made. So yeah, again, you're not on the hook for being evicted if you leave under those circumstances. And if you're on that longer lease, it prevents you from owing future rent. And it can be quicker. You're done and you're out, you're someplace else. The downside is you have to move. Otherwise you're going to be evicted. And being thrown out, having the bailiff come out is not good in and of itself. The other really downside, though, is if they file an eviction in court, you now have this eviction on your record, and that's going to make it harder to find that next place anyway. And in theory, this could lead to litigation over rent. If a landlord's like, no, you skipped out, I made these repairs, they could in theory sue you for it. A lot of landlords typically don't file lawsuits seeking money from their tenants. It tends to be more hassle than it's worth. So we already talked a little bit about the process. And they're very similar. They start out the same. Give your landlord that notice in writing. Wait for time to pass. Again, going back to what we were talking about earlier, I like to talk to the landlord first, if at all possible. If it's just a broken window, I probably, call the landlord up and say, hey, I just want to let you know this window's broken. Can you get it fixed? If they're not responsive, then go ahead and send that letter. If it's something more emergent, no heating, no hot water, no air conditioning in the summer, things like that, go ahead, send that text message. I don't want to say, sit on that for a week. You need to kind of figure out what's life endangering and what's not.
So when you say you mean the renter then would make that call to the landlord. What can legal aid do, or what can an attorney do in that case? Yeah,
so when it's if it's a situation where there's no heat or no electricity or no water, call us. Because often we're going to make that phone call for you. Or we'll find out, have you already done those steps? Sometimes folks don't want an attorney involved up front. They're like, no, the moment you get involved, it's all going to go sideways, and I get that. If we call your landlord, we're probably going to be a lot more threatening. I usually don't like putting on the trappings of an attorney. It just doesn't fit me well. I tend to do that, though, when I'm calling landlords and be like, now, don't you understand I'm an attorney, and I'm going to file a lawsuit against you. And what we're going to file is going to be a restraining order. I don't know if you can go forward a couple of slides, Cass, but that restraining order, that's kind of an emergency issue. And it really does need to be that lack of heat, lack of water, lack of electricity, the things that your basic necessities to survive. That process is a lot more complicated. It's not something I would typically suggest people do on their own.
I've never heard that restraining order being used in that case. I always think of restraining orders in terms of like domestic situations. So what does that restraining order actually do? So
the restraining order, it's weird. We call it a restraining order because that's what it's called under the rules. It's actually an order to go do something. And so that something will typically be like, get the electricity on immediately, get the water fixed. It's a process, and it involves actually filing a lawsuit in the court. These can be done on an emergency basis. So when we've done them in the past, we will go in, we'll tell the landlord, you have until 3:00 tomorrow afternoon to get this problem resolved. If it's not resolved by then, we will be at the court at 3:00, and we will meet with the judge, whether you're there or not, and ask for an emergency order. At that point in time, often the judge will sign that, and then there'll be a hearing scheduled a week later.
So in that case, if the utility is in the name of the tenant, that doesn't work, right?
That's right. If you are responsible for paying the electricity and you did not pay the electricity, and that's why you don't have electricity, our response is going to be, you should go pay your electricity. We're not going to file a lawsuit against your landlord. This is where, we had a case here in Lancaster a couple years ago where the landlord was heated by a fireplace. The landlord had climbed on the roof and jammed things down the fireplace so that they couldn't use the fireplace and heat the property. The tenant can't fix that. They're not responsible for that. That's one that we went to the judge and we're like, you believe what this guy's doing? And he's like, yeah, I can't believe that. Here's your order. So we've done it also where the landlord didn't pay the water bill. Or what we see a lot is landlords upset with the tenant, either they didn't pay rent or they've done something. And so they'll call the utility company out and be like, I want the utilities turned off at my place. And the utility company's like, okay. Or we had, I like telling war stories, I'm sorry. We had a situation down south where the landlord just went out, they dug up the pipe leading to the house, they installed a shutoff valve, and then turned it off and then buried it. Because they were upset with the tenant because she was allegedly harassing their kids. Again, this was the parties just, it was a bad relationship. It was never going to work out.
So what happened though?
We called the landlord and said, you can't do that. He's like, yeah, I can. And my colleague said, no, you can't. We'll see you at court tomorrow. He's like, wait, are you serious? And I'm like, yeah, we're serious. He's like, well, maybe we can figure out a way to get this resolved. So that was when we didn't have to file in court, but we were ready to do so. A lot of times when folks hear from us, and our response is, do you have an attorney? No. You might want to go talk to one before we see you in court tomorrow. And that often gets things resolved quickly. So if a restraining order is us breaking out, busting the emergency glass, a receivership is the most extreme thing that we do. That's where we actually ask the court to declare that the property is a public nuisance and needs to be taken over by somebody else. We've done that in a few cases. We don't like to do that for individual properties. This is more for the mobile home parks that are just neglected or apartment complexes.
With the Zanesville think tank on poverty, we've been involved with the Kemp properties. He was a known slumlord, drug lord, lots of things happening on his properties, and so he went to prison. And so then the city was left with all of these houses, and they were not equipped to take them on, but they were in their laps, so then they had to find a receiver for these properties, and it's still very twisted. It's kind of a mess.
These things are an absolute mess. They're incredibly time consuming, and it can lead to a lot of uncertainty for the tenants. So it's an option. Before we get involved in asking the court to do something like that, we're going to want to spend time talking with the folks out at the property. Cass?
Question from the sound booth, aka Peanut Gallery. Oh, y'all doing a good job, by the way. I'm just soaking it all in. Do you have to go through this process? Because I know someone in Facebook land might be asking this question. Do you have to go through the process step by step? So escrow, restraining order. So all the steps, or can you just, or if it's extreme, you just skip?
Yeah, it really depends on your situation. I'm going to give you a very lawyerly answer and say, yeah, it depends. And it depends on what the problem is. So if it's a broken window, escrow or leaving is going to be your best bet. If it's a lack of heat in the winter, then the asking for a restraining order is probably going to be, you're not going to go through that escrow process. It's just too slow. Escrowing your rent after 45 days in the middle of winter without any heat is just not an effective solution. The receivership option, that's for the place that the landlord is just completely absent and it's falling down. So no, you don't have to go, these are 4 different options that you have to pick the one that's going to be the best for your situation.
Another question from the Peanut Gallery. So what are the consequences for landlords doing things maliciously? So like you shared, landlords installing shutoff valves or turning off utilities with malicious intent. So person's been paying their rent, person's been a good tenant, they just probably rubbed the landlord the wrong way, and the landlord just said, you know what, I'm just going to make you suffer. Are there any legal ramifications for that landlord?
Legally, yes. Practically, it's really hard. So yes, in theory, you could sue your landlord for breaching their obligations under the revised code or their lease by shutting off your utilities. And such a lawsuit, they're actually, it's called a fee shifting provision, which means that they can be responsible for paying your attorney's fees for bringing that lawsuit. The problem is you have to, what are your damages in that situation? So if you were a day without, 2-3 days without utilities, what economic damages did you suffer? Those can be really hard to show. And then you can, in theory, get punitive damages. Those are damages that are designed to send a message to the landlord that what they did was wrong. Those are hard to get in Ohio. And so it's legally out there. We bring those in rare circumstances where the actions are particularly egregious. And a lot of times we end up settling those out because if you're behind in your rent and these things happen to you, well, now your landlord has a claim for that back rent. And so I don't like bringing lawsuits where the only real person getting any money out of it's the lawyer. So we will bring those claims as part of a claim for a restraining order typically, but we don't always follow through and take that to court. Usually they get resolved out. So the law provides an answer, a remedy. It's just a remedy that can be hard to access at times. Was that responsive to your question? Okay. So that's kind of, the relationships breaking down. You've had to go down one of these options. Let's talk a little bit about the ending of a relationship. Hopefully, you've made it through the end of your lease. You decide to go elsewhere voluntarily. You pay your final rent. You give your landlord, a forwarding address so they can send your security deposit to you. And that's how most leases end. But again, nobody comes to me and are like, you'll never guess what happened. My lease ended and I walked away and everything was great. When they're coming to me, it's because somebody's filed an eviction against them. An eviction is where your landlord is simply asking you, leave the property, or I want to ask the court to have you kicked out. And what happens when the court kicks you out is the bailiff from the court will come to your house, tell the landlord, all right, you can go in, and they will take all of your property and they will set it on the curb. And when that happens, a lot of your property is either going to be damaged or it's going to come up missing. So you do not want that to happen. You also don't want to have an eviction on your record because future landlords are going to see that and they're not going to want to rent to you in the future.
Josh, I think something that's very confusing for people, so they get a notice that say they have a 30-day eviction, right? And so people are often wondering, it's like, oh my gosh, what does that actually mean? Do I need to get out by this date? What does that really mean? Yeah,
those notices before an eviction gets in court, they do mean things, but they don't mean what people think they mean necessarily. So you can get evicted for not paying rent. You can get evicted for breaking your lease term. Or staying past your lease. So let's talk about those notices and kind of in the context of those three things. So if you don't pay your rent, what your landlord could do is give you what's called a 3-day notice to leave. And your initial reaction might be, well, this doesn't mean anything. It's just typed up and it's not from the court. Well, it does mean something. It means that if you're not out after those 3 days, that your landlord can then file in court. So that first one you're going to get is 3-day notice to leave the premises if you didn't pay your rent. They can give you more time than that, but the minimum they have to give you is 3 days. And it's going to be just a regular piece of paper that should say, I want you out on such and such a date because you didn't pay your rent. There's usually going to be a box or something that's got some legal language that's required to be in there. And if you're out before then your landlord's can't file an eviction against you. If you're not out by then, your landlord cannot just come and set you out. The sheriff cannot and will not come and just set you out. If they do, if your landlord comes on day 4 and is like, you weren't out, I'm throwing you out, and they start trying to set you out, or they change the locks or do anything like that, your first call needs to be law enforcement. Your second call needs to be to me.
I've also heard people say that, they get that 3-day notice, but it doesn't look like it's anything official, so do they need to pay attention to it?
Yes, they do need to pay attention to it. That's your warning sign that an eviction might be filed in court. It's also sometimes the first time people learn that their rent didn't get paid. Cass?
I've heard stories of landlords not providing that 3-day notice. Do they legally have to provide that 3-day notice?
Yes, revised code says that prior to filing an eviction action, they have to provide that notice, and they will be required to provide a copy of that notice in court. Now, how they provide it is they just have to stick it on your door. And do they always use the best tape? I actually live where I live. The property next door is a rental. And I found their 3-day notice in my yard. I'm guessing the wind just blew it off. So they're required to provide it. They will have to prove it in court. I've had a number of cases where my client has said, I never got it. And I'm like, yeah, you may not have. But they're saying they're going to testify that they gave it to you. They've got a copy of what they gave to you that's signed and dated. It's going to come down to who does the judge believe. And I can think I have one situation where we ended up the judge believed my client that it wasn't given, and that's because the landlord was just known to be a liar. Outside of that rare circumstances, the court isn't probably going to find that they did provide it, as long as they have a copy of what they gave. So if you're not out after those 3 days, then the eviction is going to be filed in court. You're going to get a copy of that. That is going to be also, here in Lancaster, I think it's going to be chained to your door by the bailiff, and it will be from the court. And it will be a summons that says, here's your court date. You need to go to that court date. If you're in Lancaster, we will be here at the court to talk with you. Call us. As soon as you get that complaint from the court, call us. It's much easier for us to talk with you in advance to figure out what we can do as opposed to 15 minutes before your hearing. At your hearing, if you haven't paid your rent, you're probably going to lose your case. And then a week later, the bailiff will be out to set you out. So the process from the moment that the judge or the landlord gives you your 3-day notice, you're looking at 30 days about before the bailiff is going to set you out. By the time that they go through the entire process, and it can take a little bit longer sometimes. Cass.
So you went to your hearing. The hearing did not end in your favor. If you move out between the date of the hearing and the date that the sheriff comes to set you out, what happens?
Then you're still going to have an eviction on your record because the judge already made a determination that you had not that you needed to be evicted. You're not going to lose your stuff because you've already moved out. You should let your landlord know and turn in your keys still. And the reason I say that is if your landlord's suing you for damages, for back rent, things like that, there are usually additional costs associated with having the bailiff come out and set you out, so you can at least reduce those extra costs. If you're going to move out, you need to try to do it before the hearing, because even if an eviction gets filed, if you're out and have turned your keys in before your court hearing, you can still get that case dismissed. And that's better than having an eviction against you. Leisha?
I've gone to just a witness eviction court in my local community, which is in Newark, and I always, 99.9% of the time, the tenant does not have legal representation and the landlord does. Mm-hmm. And so it's just like one after another, the landlord tends to win. So, for people that, are in this situation and they're like, I'm not even going to show because I already know what's going to happen. I don't have an attorney. This is not going to go in my favor.
You should still go to the court. Some judges will identify problems with the pleadings and that you may not have noticed and just know I'm not going to grant an eviction. You didn't do it right, landlord. You forgot to give that 3-day notice, or your notice doesn't have the right statutory language on it, or you didn't wait 3 days. And there in Ohio, there's something called equity, that if it's just not fair to evict you, the judge can, in theory, not grant the eviction. So that will happen with you didn't pay your rent, but you come to court with all the missing rent and the court costs. So the landlord's made whole, if they would just accept the rent at court, and the judge has the discretion to say, you know what, the law hates kicking people out of their houses. We're going to let you stay, but you got to turn that money over now. So I would still encourage people to go, even if they don't have an attorney, but call us to see if we can represent you. Even if there's not a legal defense. So here in Lancaster, where we're at eviction court, we will be there. Even if we can't stop your eviction, a lot of times we're able to talk to the landlord and be like, hey, this person just needs an additional 2 weeks. Can you give us an additional 2 weeks? And like, grumble, 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 grumble. Okay, we'll give you an additional 2 weeks. Yeah.
So let's say, I'm in that situation, right? And I know that I can't afford an attorney, so I'm going to try to see if I can get representation from legal aid. But is it true that I have to qualify financially to be represented by legal aid?
Yes.
Okay.
So it's complicated. It's like 125% of the federal poverty level. If your household is below that, we should be able to represent you. We have to go through and make sure we're not representing somebody else, or there's a conflict of interest and some other things. And your assets have to be under $5,000, but those are often met. We can go up higher income in certain circumstances, and if you're over the age of 60, we have no income or asset caps. So we don't care what your income is for the most part if you're over the age of 60. And we will check all of those things quickly at court. Here in Lancaster, even if you're over those, we can still give you some general information to help you understand what's about to happen, even if we can't represent you or provide you specific legal advice. The best thing, I would encourage people, if you're making $1 million a year and you're being evicted, don't call us. I'm going to say, unless you've got a family that's like 100 people or something, we're probably not going to be able to represent you. But if that's not you, give us a call. I'd much rather you call and us talk to you for 5 minutes, be like, I'm sorry, you're over income. Then you screen yourself out and you would have been eligible for our services. So we talked about the 3-day notice. Leisha also said something about a 30-day notice. There are times where you're going to get a 30-day notice. You've been paying your rent, but you're in violation of the terms of your lease in a way that are bad. So weirdly, if you go out and you start punching your neighbors, you get a 30-day notice. And it'll say, or it should say, you need to stop doing what you're doing, otherwise we're going to evict you. If you're just not following the terms of your lease, sometimes that could be just a 3-day notice. But a lot of times you'll get that 30-day notice. You'll also get a 30-day notice if you're on a month-to-month lease and your landlord no longer wants to rent to you. The key, like we talked about with the escrow, is that's 30 days before your rental period. So if your rent's due on the 1st and your landlord gives you a notice to leave, that they no longer want to lease to you on the 15th, well, pay your rent on the 1st when it comes due, because they can't actually have you out until the end of that next rental period. So that it usually ends up being 45 days. And that 30 days is, it's 30 actual days. It's not 1 month. So every year, usually at the end of March, I win a case against a landlord who gives a notice on January 31st to be out at the end of February, because they forget that February only has 28 days. That happens every single year.
You're guaranteed win.
Yeah. This year, I brought it to the attorney's attention, and he's like, Josh, I feel like we've done this before. I go, yeah, we did do this last year. But then after that 30 days is up, then it's just like a non-payment. You'll get that. Then they have to give you a 3-day notice, and it's then that they can file in court. I think I covered staying past your term all at the same time. If you are past, you had a 1-year written lease, the landlord made it clear he's not renewing at the end of your lease, and you stay, they just have to give you a 30-day notice unless they accept your rent. If you don't do anything, you just keep paying your rent, then your 1-year lease turns into a month-to-month tenancy after that. One of the questions I get all the time is, I heard from lawyer Google or my friend who's not an attorney that I get more time if I'm pregnant, or I have kids in the household, or I have a disability, or I'm elderly. In Ohio, none of those things matter. You do not get an additional 60 days. For some reason, it's always 60 days. I'm not sure why. But maybe that's true in some states. It's not true in Ohio. There are a lot of things that I didn't touch on. I didn't touch on fair housing, which is an incredibly important thing. If your landlord is discriminating against you on the basis of your skin color, on the basis of ethnicity, religion, gender, familial status, you should call us. That one, it doesn't matter what your income is. If you think that's happening, that's something we can help you with. Please give us a call on any, if you have any questions about fair housing rights.
And you are, call you, so your legal aid is not just Lancaster, right? It is surrounding counties as well.
Yeah, so my office covers Fairfield, Ross, Pike, Pickaway, Jackson, Hocking, Fayette. But we have other offices that cover, so every county in Ohio has a local legal aid office. If you're here in Lancaster, you're going to call my office. We're out of Chillicothe. We have a small office at the Chase Bank building downtown. Or just come see me on a Tuesday. I'll have everything that we can get set up at that point in time. The easiest way, though, is to call our office. Go to our website, www.seols.org. Call our, you can apply for our services online. But the key is call us as soon as you get court papers if you're being evicted. The longer you wait, the harder it is to sometimes fix, or it's less time for us to get back to tell you, look, there's nothing that can be done. You're going to lose. You need to start looking for that place to go.
Another thing that I hear people say, I do some charity work in my own community, but people will say, well, legal aid, they're just so busy that they can never get to my case, right? And I think that's just something good for people to understand how legal aid is funded. But I just hearing from you, the number of attorneys that you have in your office, it does control what your caseload can be, correct?
Yes. We had more than 1,000 folks who called us last year who were eligible for our services and were the types of cases that we could help out with. Of those, 80% of them, we gave them advice on what to do. We simply, with 7 attorneys and a paralegal, covering seven counties, we simply lack the resources to represent everybody in their cases. Housing is almost an exception to that because we've got a clinic where we are here every Tuesday in Fairfield County. And even then, there are still folks who are like, there's nothing we can do. Go tell the judge this, but it's probably not going to work. So yes, we are incredibly busy. We try to get in and help as many folks as we can. But I think folks need to also remember at the top when I was introducing myself, I'm here talking about housing today. I was right before this, I was calling one of my colleagues to deal with a divorce case that he's trying to work through. I've got a call with my paralegal scheduled for this afternoon to go over some unemployment issues. So we do a wide variety of things.
And Kaz, that might be a good topic for a future lunch and learn, for people to understand, how we got to this situation in this country, that poor people don't have the same access to their legal rights as others, so that's no fault of legal aid, that they can only handle so many cases. But I think that's just a good systemic thing for people to understand. So that might be a good one, as well as understanding fair housing, because there are lots and lots of cases.
I don't get to be disembodied hate anymore. Thank Thank you all so much for doing this. I know there's a lot of information. Listen, if you're watching live, thank you for joining us. If you're watching the replay, let us know that you watched. As I said a couple weeks ago at church, that, if I have the tools to help you deal with a situation or help you get out of something, and I just sit back and go, whatever, I'm complicit in your demise. So I'm grateful that they're not just like people I just know, they're friends. I'm grateful to have friends like you too. And you're right, we do need to hit some of the layers and the systemic stuff that's happening, so that way people understand that, what's the best way I can put this PC? One, it's not your fault, and two, what we've been saying is real. As someone who grew up in poverty, I've seen a lot of these things happen. Even in my adulthood, I was almost evicted a couple times. But I had the financial resources that I was okay. But I know that many people don't have that, especially many people in our town don't have those resources. So
Pandemic, right? So everything is more complicated and more difficult.
Oh yeah, especially with the Josh. Can you actually, either of you, can you briefly touch on the eviction moratorium and how that has ended here in Lancaster?
Yeah, the eviction moratorium has ended here in Lancaster. It ended late May. The judge locally determined that the CDC did not have the constitutional authority to do that. That's consistent. Other courts across the country had reached that. I don't think it never got to a completely final hearing in most of those other courts. But yeah, here in Lancaster, that's really no longer an option. It was a lot more limited in scope than folks thought. You had to have lost income in 2020, and you had to be being evicted for non-payment of rent. So it didn't have the broad impact, I think, that a lot of folks. It still was helpful for some. Don't get me wrong. And even had the judge not reached that decision, next week the moratorium would have ended anyway.
Can I ask one more other thing? So I live in Newark, and I was just at in a class this morning with people that are returning citizens, and they were saying how difficult it is to find a place to live, especially if you have, depending on what's on your record, whether it's a felony or an eviction or whatever, and people are just giving up because they can't find a place, and they certainly can't find any place that's affordable. So that might be another lunch and learn that we want to do, just to talk about the affordable housing crisis that's not just here in Lancaster, but it's across the nation. I think that's a really good thing for people to understand. And this woman that I talked to this morning, there are so many rules in our system, so she would like to find a place where she can be with her fiancé, but in the shelters, because they are not married, they're not allowed to be together. And she said that she's at the point where she's just going to pitch a tent somewhere because she can't find a place that they can afford. She can't get her children back because there's no place that she can afford. And so now she's reduced to this situation, and she's just trying to get her life back together. So I think the increase in the rents is it's exponential in communities like mine and everywhere. I think the rents are just climbing, and people are really giving up hope.
Actually, Alicia, can you talk about, I know a lot of people are not familiar with the work that we're doing with the think tank, so can you talk about the advocacy side of our discussion?
Sure. So just an example, one of our early wins in the Newark think tank on poverty was, we were hearing from people. I remember there was one guy, and you can watch it in our documentary, which is called Upriver, but we were in a think tank meeting, and he was talking about, he had been incarcerated for decades, a couple of decades, and he got out and he wanted to live with his wife. And she was living in metropolitan housing and subsidized housing, and he was not allowed to live with his wife, right? Strike one, right? So, he's devastated. He had this plan. He didn't know that this rule was in place, so he couldn't do that. So he had to find a place to live. He also had to find a job, and he had these things on his record. So, and he didn't have a car. So he spent, the first few days just walking around the county, putting in application after application, and he got nothing. He got no callbacks. That little box on the application that says, have you ever been convicted of a felony? And he knew if he checked it, his application was going in the trash. And if he didn't check it, and then, they had the interview, he's like, he couldn't figure out a way to go forward. So anyways, I mean, he ruined his feet. He had bad shoes, it was tragic. In the end, he said, he appreciates all the charity, that people want to, give him, but he just wanted to do for himself. And I think, adults want to be treated like adults. Adults want to be adults. And, but when the system is against you like that, you can't live with your wife. There's no public transportation, so you can't get around. And then you can't get a job or you can't get a place to live because of these rules, that say that you can't have any of those things. So it just makes things so much harder. So one thing that we did with the Newark think tank is that there was a movement in the country to ban the box, and that was to get that question off of employment applications. But something that we could do locally is to get that question off of applications for housing, right? Because that is we believe that housing is a human right. And so, together, people that are directly affected by this, people like us that are trying to make change with the voices of people that are really hurting, those are the kinds of things that we want to do with the Lancaster think tank on poverty. So we'll be continuing to work together. And I know Kaz and Josh were walking around the neighborhood talking to people about their concerns, and we are really hoping to bring together people from the neighborhood and from the community, people that are experiencing poverty, to talk about what's going on in Lancaster and what we could do together.
So again, thank you so much for joining us. I mean, something I've learned through my experiences, both pastoring as well as teaching, is that a lot of stuff is solved when you have a roof over your head. Housing first, you all know what I say. If we want to end homelessness, let's give them a home. They can get employed. Kids can go to school through the McKinney-Vento Act, but a lot of places won't employ you if you don't have a established residence anywhere. Right. So this is part of the reason why we're doing this work, and also, we as Christians have a responsibility to help those who can't help themselves, to speak for those who can't speak for themselves, and that's something. Love your neighbor as yourself. So if you don't want to be homeless, I'm just saying, if you don't want that for yourself, we have to do what is necessary to get people to where they need to be and make people whole. So this is not just a one-time deal. I think we need to do an evening one of these. What do you think? We're going to do an evening one of these. Also, speaking of evening one of these, next week, June 30th, from 6 to 8, we're going to be here with people from the neighborhood, also people from Lancaster, talking about their concerns, what they need, what are they looking for in terms of services, how can our organizations help them get to where they need to go. So if you're watching this, June 30th from 6 to 8, we'll be in here. We will have snacks. Yay, snacks. And honestly, I would love to pack this place out. I would really love to pack this place out. So if you have concerns, it could be anything from people are doing drugs in the house across the street and is bothering you to, my landlord has not fixed my steps in the past 5 years. We want to hear those things from you. So come and join us for those events. Also, remember, Sunday is a double church service. So 12 o'clock, we'll be here. Pastor Trey's going to be preaching. And then 6 o'clock is our worship and word encounter, 6 to 8. So we'll be having worship leaders from across the area working as one big old team. And then I'm going to be preaching. So we'd love for you to come join us. Also, July 4th, we're having a family Sunday. That means service will be online only. So as I run back and go into my tech bubble, do y'all have any parting words?
Thanks for having us, Cass.
Yes, Kaz, this is really important. I hope that we do more of them, and I really hope that people will come out next week. This is an opportunity for you to say what's going on with you, what's keeping you and your family and the neighborhood and Lancaster, what's keeping people down. And we know there are lots of things that people are struggling with, and especially with this pandemic. So please come out. We're here to listen, and then we're going to work together to learn how to fight back. And I mean that in a peaceful way, but we can work together and we can make change happen. So we look forward to seeing you next week.
Awesome. Well, thank you all so much. And if you have any questions, if you've been watching this, comment on the video, or you comment on video. You can email us at admin@truevisionlancaster.org if you have any questions about what you've seen today. Again, if you know anyone who's dealing with housing issues, please share this presentation with them. It has been very vital. And also, we have resources available on our website, truevisionlancaster.org. Click Community Resources pages. It has links to the Think Tanks of Poverty, as well as Southeastern Ohio Legal Services. And come see Josh on Tuesdays from 9:30 to 11:30. All right, everyone, have a wonderful day and go in peace, knowing that you are loved.